Sadly, legal challenges to reductions in care packages are becoming more frequent due to arbitrary cuts in care services. There is more pressure on social services to deliver care packages and less money to provide them. If you need assistance to meet your essential daily living needs, such as dressing, meeting your personal hygiene, meal preparation, shopping, cleaning, etc., and consider you should not be expected to manage without assistance because you are disabled, older or vulnerable, you may be entitled to assistance from social services. If social services accept you have care needs and provide you with a package of care, they will review the level of care they provide on a regular basis. This is usually annually. Due to the reduction in local authority budgets and more people seeking to access those resources, local authorities are struggling to meet the needs of all those in their community with care needs. In light of this, it is becoming more common for care packages to be reduced, since local authorities are unable to provide services to every individual that has care needs. They are free to choose which categories of assessed needs necessitate the provision of services. In order for a local authority to lawfully reduce your care package, they are required to carry out a full reassessment of your care needs. If they fail to do so, any decision made to reduce your care package will have been reached using an unfair procedure which is challengeable through the courts. If a local authority reassess your needs and decide that continued services are required, they are legally required to produce an updated care or support plan for you. For the decision to be lawful, the plan must set out what your needs are and how those needs will be met. If your needs have not changed since the last plan was produced, the local authority has to be able to provide valid justification for reducing your package and must be able to illustrate that your needs will still be met by the reduced level of care being offered. In order to challenge a reduction in your care package, it is important to have strong medical evidence from your GP and/or any specialist doctor who is involved in treating your condition. Such evidence should support what your needs are, which are not being met. It may be difficult to challenge a reduction in care without such evidence. Although local authorities will attempt to provide care services in the community, if you require care for a large period of every day and night, local authorities are likely to consider whether it would be less expensive for them to provide care to you in a residential setting. If the care package you are seeking is very costly, this is a potential risk you need to be aware of. You are excluded from being provided with residential accommodation if you do not have adequate immigration status, unless the provision of services is necessary to avoid a breach of your human rights. In such cases, the local authority will need to carry out a human rights assessment for you before making a decision. Legal aid is available to instruct a solicitor to challenge an inadequate community care assessment of needs. To be eligible for legal aid, there will be an assessment of your financial means, the merits of your case, and whether there is a sufficient benefit in bringing the case. To check if you are eligible for legal aid, you can go to the Ministry of Justice website and insert your details into the legal aid calculator. A solicitor can assist in obtaining the necessary medical reports and providing specialist advice.